Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a very important book, which is going to be a series of books eventually, from Cambridge University Press. It's on criminal law. The title of the book, and this is where we start getting complex immediately, is Core Concepts in Criminal Law and Criminal Justice, Volume 1. It's been edited by four people and a large number of contributors. Kai Ambos, Anthony Duff, Julian Roberts and Thomas Weigend are the editors. As I said, it comes from CUP and it's a hardback book in a series which are going to be developed over the next few years. I'll give you a little bit of history about the book in a moment. I've given a title for our book review, the following: An Ambitious Review of Criminal Law Today, the first of 3 volumes. And in fact it's really reviewing, I think, where we are at the moment with criminal law in a comparative sense. The problem being that we, in my view, have had over the years I've been studying criminal law, which is actually 50 years, we've been looking at a period when much of it was based on common law here in England and Wales, moving much more to statute-based offences, and then of course the criminal procedure rules, and of course the problem of the aim of wanting to codify criminal law, which I still believe should be the aim of a government in the future. I think it's still some way off, but it's something that's been talked about for some time, and I think codification of the law in this area would be of great assistance to everybody. I say it because I mentioned it again in the review, but the problem with criminal law is people think, oh, it's quite easy. Actually, it's really hard, and it's difficult to teach, and because people come into it sometimes with preconceived ideas. Let's look at the book anyway. Here it is. This is an academic work. It's a hardback. That's the front. You can see the volume 1, and then you can see the actual title there. Then you can maybe be able to make out a little bit of what I'm using in the review, which is the blurb on the back. And if we open it up on the back, we've got a useful index, which is by page numbering. So you should be able to find things pretty quickly when you're looking. It's not a detailed index, but it's good enough, I think, for what our purposes are. And it does cover specific offences, like, for instance, there's aiding and abetting is covered there right at the beginning, I noticed. Then there's the beginning of the index. Then you've got a bibliography, which is actually at the back. Now, the bibliography is always important, but the way that they structure this book, you can see in the middle of the book, the bibliography is for each part of each of the chapters, basically. So it makes it a bit easier than having a huge bibliography right at the back. And there will, of course, be some sort of repetition. That states the mission statement for Volume 1, which is quite detailed, and I'll talk a little bit about it. It mentions the people who are involved. Kai Ambos, for instance, has been a judge in the Kosovo Specialist Chambers at The Hague, and Professor Anthony Duff will be known to many people from the University of Stirling. You've got Professor Roberts, and you've got Dr. Weigend, and you've also got an additional person who's the assistant editor, whom I haven't mentioned before. That's Alexander Heinze, who's an assistant professor at Göttingen School of Law. There's the front page anyway, and then after that we've got the blurb, the actual information about the book, then the contents, split into various parts, as you can see, actually 3 parts, which I'll talk about again in a minute, and then the various chapter headings, you can see running all the way through, and then getting to the final chapter, which is chapter 12. Then there's a short preface which explains where this book came from and how it's developed. A very useful list of abbreviations, something we do need in criminal law more and more today. And remember, this isn't comparative work, so therefore it's important to think of the different jurisdictions. Then you've got the contributors and their biographical details, very substantial number of people involved, as you can probably see. Then we get, after that, the introduction itself, and then you can see some introductory remarks from the main editors, and as you can see running through, there are you can see footnotes appearing, and there are numbers, Roman numeral numbers actually, for some of the subheads that are used. And as I've indicated, at the back of each of the main chapters you have a basics of biographical details and further reading, which assists. As I say, it runs to something approaching 500 pages in total. I found it a very interesting book. It's not for the beginner. That's one thing that I would stress right at the beginning. So what do I say about it? This book is the first volume of a 3-volume AIM series examining a modern approach to criminal law at a time when it's desperately needed. That's my view anyway, and I think it is, because I'm not happy with the way criminal law is currently being exercised in terms of its jurisdiction. There are a lot of problems with it, and it does need some serious thinking about where we go in the 21st century. CUP, that's Cambridge University Press, are to be congratulated by identifying the need for a comparative conceptual analysis of criminal law and criminal justice at this time. And the service which CUP offer us as practitioners and as researchers is, I think, of immense value, and obviously collaborative works such as this new series covering crime remain invaluable to us. And I think anybody who has an interest in this area will find this book of some help. I've tried to make sure that the review is not too detailed and light enough so that people can understand where they're coming from. The first volume, obviously, of the series then is entitled Core Concepts in Criminal Law and Criminal Justice, and that will be what is going to be a 3-volume project, at least for now. The basis of the work emerged from the Anglo-German dialogue project, which took place some time ago. So the 12 chapters of this book are based upon the drafts, which was subject to a series of biannual workshops. And in the first volume, there are 3 parts split into an introduction in part 1, followed by part 2, which covers what we call criminal law, and part 3, which is devoted to criminal justice and procedure. And in total, 22 contributors are listed for each, listed by chapter, depending on who has contributed to what, and they give their own specific expertise for the subject heads covered. Now, the main editors, as I've indicated, are Ambos, Anthony Duff, Julian Robertson, Thomas Weigend. And they've successfully attended a trans-jurisdictional debate, that was their aim, and agreement, which can often, of course, be beset by mutual misunderstandings. And, of course, that's one of the big problems in criminal law anyway. It's an understanding of what the purpose of criminal law is and how the procedures operate. The work is designed specifically for legal professionals and academic researchers engaged in comparative criminal law, sometimes using the same terms with different meanings, or different terms which mean the same thing. And of course, again, that can be a problem because of the detail which comes into criminal law itself. Now, they write that, quote, although English is the new lingua franca in international and comparative criminal law, there are many ambiguities and uncertainties with regard to foundational criminal law and criminal justice concepts. So you get the general flavour of where they're coming from. It's very true, although there appear greater similarities among diverse systems of criminal law and justice than is commonly realised, I would suggest, even though the study and practice of criminal law is much harder than many initially realise, as every student will testify. And certainly I found that with the students I taught. The mission statement of the volume then and the series will be to explore the foundation principles and concepts that underpin the different domestic systems. Remember that we've always had the aim of trying to have some sort of standardisation so that the legal systems don't appear to be completely at odds with each other. That's been an aim for a long time. It's not really going that far at the moment, but we've certainly made some steps forward. The editors have honed in on both the German and the several principled Anglo-American jurisdictions, which are employed as illustrations of the wider common law, civil law divide, which will, I think, benefit everybody who's studying comparative law, because again there are very interesting splits between both common law and civil law divides. Let me conclude this with this statement that CUP give us the following content for the first volume. This is the detail that you may be looking for. There's a comparison between Anglo-American with German concepts, doctrines, principles and structures. So that's the comparative bit. They have then set out chapters which are conceptual, transparent and explicit as to their methodology and research questions, including factual scenarios to illustrate the concepts being discussed. And all 22 contributors come from distinguished scholastic backgrounds with international reputations, and of course from diversity backgrounds with either a more theoretical, normative or a more empirical focus, which I think adds additional authority to what is an excellent first edition of the eventual series of books we're going to get to help us evaluate the criminal system of law. And I think it's a good step forward. The publication date of the volume, this first volume, is given as the 1st of December 2019, and I of course am recording this at the earlier part of 2020. As I said, let's just have one last look at the book. You can see the front, an interesting bit of modern art at the front. You can see it's a hardback. There's the spine and then there's the back. Just opening it in the middle, I'm just going to find something. Proportionality of punishment. Proportionality is always a very important question these days. It's a word that has arrived in English and has a much stronger usage today than it used to do. But this gives you an idea of the book. You've got the footnoting there, and obviously the subject matter. You've got various subheads, which you can probably see there, to deal with it. And then it talks about various philosophers. We've got Kant, Hegel and Fichte and so forth, Fichte, depending on how you pronounce it, and a whole range of other people. Let's see what else is mentioned. In fact, no others, but they haven't mentioned a few. But you get an idea of the heavy nature of the book itself. We're looking again here, just going a bit. This is due process. Again, you can see the detail used. All in all, I thought it was a very useful book. I was delighted to be able to review it, and I'd like to thank CUP very much for sending it to me for a review. And I wish them very great success, the editors and all the people involved, with the further books as they arrive. Thank you to all. Bye-bye.